So how can a foreign entrepreneur become a permanent resident of the United States? In this video, we're going to go over the various permanent residence categories that a non-US citizen entrepreneur who wants to build, grow businesses in the US can use to obtain a green card and become a permanent resident so that they can grow businesses in the US. One important thing to notice, this is a bit of a follow-up video on a previous video I recorded on the various non-immigrant visa categories, so temporary visas for entrepreneurs. This video, unlike the previous one, will focus on green card permanent residence, not temporary visas. So if you're more interested in the visas or want to watch that video, take a look at that one as well, as this one's a bit of a follow-up. First and foremost, welcome back to the channel. My name is Adrian Pandev. I'm an attorney who helps foreign nationals navigate the US legal system, helps them build companies, helps them obtain the right visas, immigration status in the US. So this video is right on cue with what I do day to day. One thing I want to mention is if you like the content, like the video, please hit the like button, subscribe to the channel. That helps me tremendously. Also, I promise, I know behind me you see those bookshelves that are empty. I moved into a new office, so I will be filling those, and we'll make sure the background's a bit more, better looking, let's call it, for future videos. Now, that being said, let's jump right into the video and let's talk about these various green card permanent residence categories. Now, the first thing that I want to mention is in this video, what I will focus on is the pros and cons of the various categories and how they benefit foreign entrepreneurs. If you want to have a deeper dive into the requirements and how you can obtain one of these green cards, I have recorded separate videos on that, or some topics I will be recording more videos, but the goal of this video is not so much to go into depth about the various requirements and how one can satisfy those for these categories, but more so to give an overview and explain the benefits of each and every category. Okay, so the first category worth talking about is EB5. So EB5 is an investor visa, an investor green card, and basically the applicant has to invest either $1,050,000 or $800,000 into if it's $800,000 into a targeted employment area. And the idea is that if that investment is made and the investment creates 10 US full-time, called US jobs, in that case, the applicant can receive US permanent residence based on that investment and the creation of those jobs. Now, when it comes to EB5, I think EB5 is a great option for a foreign entrepreneur that's looking to invest into a cash-intensive business in the US. So basically, if someone is looking at the business plan, and when the business they want to develop in the US involves an investment and a significant substantial capital investment, and it's a type of business that will employ a lot of workers. So what I often see is construction, right? Real estate development, hotels, like building hotels from scratch, restaurants, essentially companies and businesses that just require a lot of workers to operate and require significant capital investments. If this is the type of business plan someone wants to engage in, then EB5 can be great, because while developing the business and creating that business and growing that business that the investor already wants to partake in, they can simultaneously obtain a green card without having to do much differently. On the flip side, the disadvantage of EB5 is the same thing. It's this capital investment and the job creation requirement. And basically the issue is that a lot of businesses, think online businesses, software as a service, advisory, consulting, sort of professional services businesses, just don't require that kind of cash outlay to start. And also they don't require that many employees immediately in the first couple years of the business. So that is the biggest disadvantage for EB5, that a lot of business plans are not going to require that kind of investment or that kind of job creation. And what I see is when people really want to qualify for EB5 with these business plans and business models that don't require a lot of workers, there's a lot of artificial sort of creating of hiring people you may not need and things like that, which make very little business sense and I don't like. So basically, the biggest disadvantage again is the money and the required jobs. Additionally, one thing to consider with EB5, and this is a bit of a disadvantage, is that initially the individual obtains a 2-year conditional green card, and then after the 10 jobs are created, those conditions are removed after a second filing. Now, the issue with this is that basically instead of it being a 1 filing process, it's a 2 filing process that has a 2-year period in between the first and second filing. The problem with this is, again, immigration processes, immigration lawyers, legal fees, USCIS fees, stress, delayed travel, potentially the classic stuff why no one likes to be in an immigration process, right? One thing I wanted to mention, and I forgot to mention on the pro side and a benefit of EB5 is sort of a little bit the direct simplicity of the process. And what I mean by that is that the requirements are outlaid. If you're making the cash investment, if you can document it, there's a lot less discretion than in some of the categories I'm going to cover in a little bit, because it's essentially money and job creation, improving the lawful source of that money. That's the main part of an EB5 petition. So that's an advantage. Now, one point I wanted to mention about EB5 that I've not say before, but I think is important to note, is that very often EB5, the EB5 option chosen by the investor is what's called the regional center option, where the capital is invested in this regional center, and the regional center ensures the job creation and all of these items. And basically, the simple way to think about it is that for most investors that invest in regional center, there's less work for the investor to do. There's less planning, and you're not actually building out a company, but you've invested in this accredited, approved project. Now, what many entrepreneurs do is they invest in the regional center, and once they obtain permanent residence through that regional center investment, they go ahead and build their U.S. company. And basically the U.S. investment, like the one the entrepreneur wants to build, the U.S. company they want to build, has nothing to do with the EB5 investment. They just use the EB5 regional center process to obtain permanent residence, move to the U.S., and grow and scale their U.S. businesses. But to sum it all up, EB5 is a great option. Obviously, it requires a lot of planning, a lot of making sure that it's the right fit. But if it's a cash-intensive business that requires employees, EB5 may be a great option. One big disadvantage also of the EB5 category is timelines. So basically, it can take several years, up to 2 years very frequently, for these EB5 petitions to be adjudicated by USCIS. Then, depending on the country of nationality of the applicant, there can also be delays in obtaining permanent residence through the adjustment of status or immigrant visa process. So to put it very bluntly, EB5 is not a type of green card category that can be premium processed or is going to move fast. These are slower moving cases, so this is definitely something to also keep in mind. Now, the second option that's worth talking about is the EB1A Extraordinary Ability Green Card. Now, unlike EB5, this category focuses not on any particular investment or is not so much focused on money, but more so on the accomplishments of the particular applicant. So in order to be considered of extraordinary ability and to qualify for permanent residence under the EB1A category, the individual applicant petitioner has to show that they're at the top of their field, and they have national or international recognition. And basically, unless someone has won major awards, in most cases, what these cases entail is proving that the individual meets at least 3 of 10 criteria that would establish that someone is extraordinary. So these are things like having publications, receiving really high salaries, working in critical leadership roles for important organizations, and many others. And the idea is basically to show that the individual is at the top of their field, that they're highly respected, highly accomplished, and sort of have a name in their field as someone who is at the very top of what they do. Now, the way this comes into entrepreneurship is that this category is often used by either entrepreneurs who've already had significant success building companies, so individuals who have, raised significant capital for companies, have led unicorn companies, have taken companies public, basically tremendous entrepreneurial success that you can show, that you can carry over now to the US and apply to a US venture and grow a US company through that previous entrepreneurial success. Now, a similar or another way a lot of entrepreneurs qualify for EB1 is that they had success in a particular field. I see this a lot in sort of sciences, tech, where the petitioner maybe has not, built companies in the past that have been super successful, but for example, have several patents, they have research, they've been mentioned in media multiple times about the research and the work that they do and their findings and their success in their field. And now they're going to take that background and apply it to a specific venture. In that case, as long as the US business, the US entrepreneurial effort is related to that field in which the individual is highly accomplished and at the top of that field and considered extraordinary, then the individual can apply and qualify for the EB1A category. And the way these cases are presented is that the focus is not so much on I'm an entrepreneur of extraordinary ability who's had all this entrepreneurial success, but the focus is on, no, I'm of extraordinary ability, I'm at the very top, internationally, nationally recognized in this particular field, and this entrepreneurial venture, this business, this company that I'm launching or have already launched and I'm scaling is in that very field. So because I have this extraordinary background, I'll be able to scale it. So the biggest benefit of EB1A is that this petition can be filed under premium processing. So basically, there's a 15 business day period in which USCIS can respond, and if the case meets the requirements, one can receive a response in a matter of weeks and then go ahead and apply for adjustment of status and become a permanent resident. So it's a quick way to obtain an answer, which when it comes to immigration and especially permanent residence, any process that can move fast is a huge benefit. Another benefit of the EB1A process is that there's none of these rigid criteria like, you need to invest $1,050,000. If your investment's less than that, you can't qualify. It's much more fluid. So if you can prove that you're at the top of your field, if you can prove that you're going to qualify, well, then it can work really, really well for someone. And basically, the ability to demonstrate your case and the types of evidence you can use will vary from individual to individual, which allows a lot of planning flexibility, which is a tremendous advantage because it's not so rigid, right? Now, the disadvantage of the EB1A process is that the individual officer that's going to be adjudicating the case has a lot of discretion. So the officer has a lot of power to decide whose extraordinary, which categories are met, which are not, which leads to a lot of inconsistency in decisions. So there's a lot of frustration by applicants where, their friend with the exact same profile maybe gets approved and they don't get approved. And that just simply has to do with the officer. So while this fluidness of the category is a benefit in a lot of ways, it's also its main drawback is that it's a much more unpredictable category than others. Now, another disadvantage is simply the fact that it's an extraordinary ability green card category, and what that means is that the requirements to obtain it are extremely high. Basically, most entrepreneurs, most business owners cannot claim that they're at the very top of their field, or that they are internationally or nationally acclaimed or anything like that. So a lot of entrepreneurs are not going to qualify for this category, unfortunately, but it is a great one for those who do have those accomplishments that would qualify them for it. So the next category I want to talk about is the EB2 National Interest Waiver, which is unlike the previous one we talked about, which is in the EB1 category. This one is in the EB2 category, but it can be filed just like the EB1 by the applicant, the petitioner themselves. There's no need for sponsorship by an employer, and essentially it requires either exceptional ability or an advanced degree. So think of master's degree or higher. And most importantly for this category, what needs to be proven is that the endeavor the individual will engage in the US will have a national benefit to the US, is a good way to frame that. Now, that national benefit comes in many different ways, right? You can argue that it's an economic benefit. You can argue that it benefits the US in many different ways, whether it's research that or it's a product that benefits American consumers. It could be something that benefits American children or students. You can look at it in many different ways. The arguments that I often see and for entrepreneurs is that the business will scale to a point where it employs a lot of people. It helps essentially the US economy at large. Also, arguments I see very often is where, like I said, it deals with the product and what's being developed or the service and how it will benefit the US. But unlike with EB1, where the focus is solely on the applicant and what they're building and how they're able to build and their extraordinary ability, with EB2, the focus is much more on the national benefit of the endeavor, and then also obviously the applicant's ability to actually contribute and advance that endeavor. So it still matters what the individual applicant's background is, and one has to prove that they're able to advance the endeavor, but it's less so focused on that extraordinary ability and much more focused on what that endeavor is. Now, that being said, the biggest advantage of the National Interest Waiver process is similar to EB1 in where it's fluid, right? Like, it allows for the making of arguments. It's not black and white, like these jobs count, these jobs not, these fields are okay, these fields are excluded. That's a massive benefit because it allows one to explain how their work and how the business will benefit the United States, right? And there's so many different ways businesses could do that. Now, follow up to that is certain businesses will automatically be able, or maybe not automatically, but they're better suited and make it easier to make these arguments, right? Like businesses or that, the entrepreneurs starting that are in the, you call it medical fields, research, science, education, so many fields where there's such a tremendous national benefit to the United States as a whole. They will slot in much easier into this category. So similar to EB5, where certain businesses will be a good fit for it, this is very similar to the EB2 National Interest Waiver, where certain products, certain businesses, certain services, and certain backgrounds for the applicant themselves will lend themselves much more to these arguments than others, where it's an amazing product, it's amazing business model, but there's not really a national level benefit to the US. It's just a good business that will be quite profitable for the entrepreneur. Another advantage of the EB2 National Interest Waiver is the ability to premium process. It's a longer premium processing timeline than the one for EB1A, but at the same time, it's still a significantly shorter period than, say, EB5 or any other category, especially PERM labor certification filed by employers, where it takes often well over a year to hear back. Here there's an ability to premium process, and in, say, a month and a half, 2 months, depending on RFEs, an answer can be obtained, which is tremendously helpful given how long these permanent residence categories can take. Now, when it comes to disadvantages, the biggest one is similar to EB1, where there's so much discretion on the officer. What is in the national interest? Who can advance the national interest? These are in black and white. So again, depending on the officer, how they view the case, how the case is presented, there could be two very similar cases, similar facts. One gets approved, one gets denied, and that just simply has to do with different officers looking at the evidence in a different light, and that's just the nature of these cases. So there's a lot more inconsistency. Another big disadvantage is that it's in the EB2 category. So certain countries face backlogs in the EB2 categories. To be clear, applicants born in certain countries, especially India, China, these applicants born in these countries will, even though they obtain the I-140 approval, they obtain this petition, they will still have to wait a very long time for the green card, for the green cards to become available and under the visa bulletin. So it'll be a very long multi-year wait. So for applicants from these countries, it's often not a good choice. But generally speaking, the EB2 National Interest Waiver is an interesting one to explore for those interested in becoming permanent residents through entrepreneurship. And then the final category I want to talk about is the EB1C. That's a multinational manager green card category. And this category is very similar to the L1 visa in that essentially it requires someone to have worked in a managerial executive capacity for a foreign affiliate company of the US company, and then work in the US in a similar managerial executive capacity. Now, this category works best for those entrepreneurs who already have businesses abroad that they own, or there's a controlling group that's also investing in the US. Essentially, they're getting transferred from the foreign entity to the US entity. They're serving as a manager executive in the foreign entity, and now they're coming to the US entity to continue that work. And the idea behind this green card category is for companies to be able to expand their foreign operations essentially in the US and be able to expand businesses in the US. Now, keep in mind, it doesn't have to be the same venture in both at the affiliate company and the US company, but there has to be a common control, so similar ownership, at least 50% same ownership. Now, immediately, this category is just very well tailored to entrepreneurs who have foreign businesses, right? So if there's a successful foreign business that employs a lot of people, it is great. It's a great way to move oneself to the US and then build here while also continuing to scale the foreign operation or maintain the foreign operation. So if there is already a foreign operation in place that's at scale, this could be a fantastic option because similarly to the EB2 and EB1 categories, these filings can be premium processed, so quicker answer can be obtained, and it's just a much more faster process than say EB5 or other permanent residence processes like the labor certification process or anything like that. Another advantage of EB1 is that it's a bit more rigid, I guess, than the EB2 National Interest Waiver and EB1A categories, where as long as one can prove that they worked abroad for 1 out of the last 3 years in a managerial or executive capacity, they're working in a managerial or executive capacity in the US, showing that there's organizational structure, so there is actually people to manage, and the US business is at a scale where it requires that top manager or a higher manager within its structure. As long as this can be demonstrated, it's a bit more black and white, right? There's a lot less discretion to the officer to say, hey, you're not extraordinary, or this field is not in the national interest, or anything like that. So that is a huge advantage of this category as well. The biggest disadvantage, quite straightforward, very many entrepreneurs who want to start businesses in the US do not have foreign affiliate companies. They don't have businesses abroad. They don't own businesses abroad that would facilitate this qualification for this category. So I think many entrepreneurs, unfortunately, will not be eligible. One sort of important practice pointer or consideration is that often you could have an investor who owns a foreign business, has that structure, who invests and buys 50% or more of the US business, and then if the entrepreneur is able to work for the foreign business, they could qualify. So it doesn't always have to be the entrepreneur that owns both the affiliate and the US business, although in most cases it is. That's just something to consider. But that's the biggest disadvantage of EB1. Also, EB1C, I'm sorry. And then another disadvantage of EB1C is very many entrepreneurs want to start businesses in the US after they sell or wind up their foreign businesses, right? Well, the problem with that is that in order to qualify for this category, both the affiliate and the US business need to be operational. So that is not going to work. So essentially, if one is trying to close their foreign businesses, move to the US, and grow businesses in the US, it's just not going to work under the EB1C category. Now, before I end this video, I do want to mention there's other categories to become permanent residents, right? Like there's family-based categories, there's the PERM labor certification process that employers can file. The reason I'm not going into these is because they're not really for entrepreneurs, in the sense that when I think of an entrepreneur, they want to own their businesses, scale those businesses, apply for permanent residence on their own without needing to be sponsored by someone else and depend on someone else, work for another company. So that is why I've not mentioned those. But of course, if someone is, engaged, an early employee of a startup, there may be other options too, but I wouldn't consider those necessarily entrepreneurial visas where the individual owns the company and is trying to apply through their own company. If you have any questions or comments about all of this, post them in the comment section below and I'll do my best to record more videos. Thank you so much for watching.